A three-judge bench of the Supreme Court will decide Yakub Memon's fate today. This after a two-judge bench was split on his plea seeking stay on execution. Justice Anil Dave and Justice Kurian differed sharply on Yakub's mercy plea. Justice Dave had dismissed his plea, but Justice Kurian differed and favoured a stay, saying that Yakub's petition must be heard afresh. Now the new bench will decide whether to stay the death warrant issued by the Tada court. Earlier, Yakub Memon had challenged the death warrant, saying it was issued before he could exhaust all his legal options. Let's quickly go across to Anusha Soni, who joins us from outside the Supreme Court. Anusha, what time is this decision likely, and also what really will happen in the courtroom at this moment at 10:30 a.m. today?
Sanket, 10:30 a.m. today morning, it's actually the second matter, indeed one of the first matter that the court will take up. This is a special bench constituted of the three judges you mentioned. One of the key important points is that none of these judges were part of any of the earlier benches, neither of the original judgment, nor of the two review petitions, neither of the curative petition. So of course, if you see it in the perspective, yesterday there was a split judgment. The Supreme Court wants to give Yakub Memon, in a way, a fresh chance to put forward the technicalities and the lapses of procedure that he's been claiming in his petition. Two key points coming up today at hearing: the legality of the death warrant. He said he was not represented at the Tada court hearings, and all his legal options were not exhausted, and also a challenge to the decision on the curative petition in which the Supreme Court had upheld the death penalty. Please understand that if that petition is just submitted, is just accepted by the court, he will not be hanged tomorrow.
Okay, Anusha, thanks very much for joining us at this moment. Welcome back. A three-judge bench of the Supreme Court will decide Yakub Memon's fate today. This after a two-judge bench was split on his plea seeking stay on execution. Justice Anil Dave and Justice Kurian differed sharply on Yakub's mercy plea. Justice Dave had dismissed his plea, but Justice Kurian differed and favoured a stay, saying that Yakub's petition must be heard afresh. Now the new bench will decide whether to stay the death warrant issued by the Tada court. Earlier, Yakub Memon had challenged the death warrant, saying it was issued before he could go ahead and exhaust all his legal options. Now there are a number of possibilities, but we here at India Today are refraining from exploring those possibilities because it is in the realm of the Supreme Court. We've got Mr. Kapil Sankla with us, senior Supreme Court lawyer. Thanks very much, sir, for speaking to India Today. Now, you know, one of the most crucial aspects over here is that what exactly is going to happen come 10:30 a.m. If you could just tell us a little, you know, in layman language, what can one expect from the Supreme Court today?
You see, the beauty of our democracy and our judicial system is that a judge also can speak his mind. And I've always believed that judges are human too. In this case, there is an impasse between two judges, wherein one of them is in favor of the death penalty, the other is going by the letter and spirit of law, saying that the legal premise, the legal process that should have been followed has not been followed. Now, therefore, under the circumstances, the Honorable Chief Justice, and rightly so, has constituted a special bench of three judges who will now decide on the legality issue that has been raised by Honorable
And these incidentally are the three judges who have never heard this case before.
Yes, so that they are not biased or they do not have a previous opinion. There is no baggage that they have to deal with. They can look at it with a fresh perspective, they can decide it with a fresh perspective and see whether the legalities have been followed or not. You see, the whole issue actually hinges on two major points. One of them is what Justice Joseph has stated, that the curative petition should have been decided when he should have been one of the judges to the same. And the second is whether such a point not having been mentioned in the pleadings can be taken up by a judge suo motu. So these are very important points as far as Indian legal system, jurisprudence is concerned, and that would be decided today.
One of the main arguments was that even before all the legal recourses could have been exhausted or explored, a death warrant came along.
Yes.
And that is one of the grounds that, you know, Yakub Memon and his family
pleaded, yes,
and his lawyers are actually talking about.
You see, as far as that ground is concerned, let us be clear that the curative petition having been decided, the only question, as far as I understand, that would be before the three bench today would be whether the curative petition suffers from any illegality or not. Because that is the main question today. All of that has already been seen, decided, argued upon, and the courts, including the apex court of our country, has come to a conclusion too in the curative petition. Now the only question is whether the curative petition was followed, held or dealt with properly as per the process of law or not. And therefore what is to be seen today, and as far as I understand what Justice Joseph, Honorable Justice Joseph was saying in not so many words, is justice is not only to be done but also has to be seen to be done. It is important that the general public, that the common man, that the citizen of India feels that what has been done rightly by the apex court, because if a man is hung, he is not coming back. And tomorrow if you decide that there was some flaw in the decision-making process by the apex court, it would be a sad day indeed.
Okay. Now, just simplifying it for our viewers as to what exactly is going to happen in the Supreme Court.
Right.
The SC is continuing to hear Yakub's petition to stop his hanging on Thursday.
Yes.
Right. Also, the Supreme Court did not take any decision on Monday on the petition filed by Yakub.
Absolutely.
And that's something which can be expected.
That should be expected to be argued and dealt with today by the three bench. Having said that, the three bench usually, as far as precedent is concerned, discusses questions of law and usually not of fact. So therefore, as I said, the questions of law that have been raised by the two judges of the Supreme Court should probably be dealt with by the larger bench today. Because as far as I understand, the inherent powers of the Supreme Court under Article 142 of the Constitution of India also permits the Supreme Court to call any person or to see any document that has not been referred before.
Okay.
At the stage to see whether proper justice has been done or not. The question does arise that if there was certain understanding, as is being now alleged, why was it not brought before the trial court by the public prosecutor? And so those questions would be dealt today, because the Honorable Supreme Court has held that a prosecutor cannot be a persecutor. He is only an officer of the court. His duty is towards the court, not towards the prosecution.
Just want to understand from you that there are a couple of eminent citizens, politicians, jurists who have also approached the President, Pranab Mukherjee, to reconsider a mercy plea. Now, one mercy plea that was with the President was rejected last year.
Right.
This is another mercy plea. In the chronology or the sequence of who grants mercy or petitions, where post, say, a Supreme Court verdict today, what is going to happen to this particular mercy plea that has been presented in front of the President?
Now, there are two very interesting views on that. As far as the hierarchy of it goes, or the process of it goes, that even after the curative petition is dismissed, the President does have the power to grant clemency, and post which the Governor too has the power. Because after all, it is a state subject. So every state has its own power. The governor has, and which is quite surprising, because the governor technically would come under the President of India. But in this case, the governor himself has the power to grant clemency to a death sentence convict. Having said that, once the same has been rejected by the President, I do not think it would be just or proper
to reconsider it.
Because there is no process of reconsidering.
Is there a precedence or process to reconsider? That's the question that I was willing to ask.
Yes, so
once rejected by the President, is there a precedence in the past that it has been reconsidered?
You know, I've been trying to search for a precedence, and unfortunately, I have not been able to find a precedence to that effect. I do know about the Rajiv Gandhi murder case. In that case, when the state government decided to grant clemency, the same came before the Supreme Court, and the Supreme Court stayed it. So as far as that is concerned, there are a number of issues that would be before the Honorable Supreme Court, because they have to take a stand today as to what the just and proper law is, because there seems to be certain fluidic movement when it comes to the power of the state government, the power of the President, as well as the number of curative petitions that can actually be moved before the Honorable Supreme Court.
Okay.